100%, 100%.
Yes, you can. Yes, you can, sir.
It's better than yesterday. Thank you very much, guys. Once again, let's the battle axes get grinding because um, a Friday night is it's a tough night to sit in a class, but I'll try and make it as interesting as possible for you guys and also sharing my personal experiences in certain things that happened while I was a candidate attorney and eventually a young practicing attorney as well, where I also did weird and wonderful things. Now, last night we stopped just short of our specific cost orders. And I obviously stated, obviously, there is the general rules where the court would then grant the successful cost always follows the successful party, and where a successful party or a party is successful for the granting of indulgence, the cost order would not necessarily follow his or her way. But there is also the rules that's contrary to the general rules. Because I said to you guys yesterday that a court exercises its duty judicially, so in awarding costs, the court can also deviate from the general rule to say that although you are the successful party, there was good reason for the other party to oppose your application. And simple applications like that is maybe if I want to declare an act of parliament unconstitutional, obviously the Speaker of Parliament, they should, because they are the custodian of legislation, they should oppose an application because there was good reason why the act looked like it looked in the past, and they would oppose it. And the court won't necessarily grant them a cost order against them just because they oppose, because that's their constitutional duty to look after acts in the country. And similarly, there's other examples. Also, when granting of indulgence, say for instance, you serve a summary judgment application on me, and I fail to obviously reply in time. And the night before the matter goes to court, I serve a summary judgment answering affidavit to your application on you. Obviously, tomorrow you will not be ready to proceed because you don't have client's instructions. You need to consult with clients. So you are going to ask for indulgence from court, and the indulgence would normally come in the form of a postponement. And although you're going to be the party that's asking for the postponement and you'll be successful, you'll also be able to argue that costs is in your favor because you did not occasion the postponement. So there is the general rules that says successful party cost is awarded to successful party, and application for granting of indulgence. Although you are successful with getting that indulgence granted, you don't get costs. But there's also the opposite that's true of those things given certain circumstances. So I just want you guys to also bear that in mind. Now I want to move over and move away from, and I need to now see where's my slide. Where am I on my slide? Okay, there's my active slide. And that is the one that says attorney client own client costs. And I actually spoke to you guys about that. And I just put up this example. Ace and Closey and Dali agreed on a day fee and also a higher hourly fee for consultation than the prescribed tariff. So that is allowed under attorney own client. So Makobani and Co will have to pay the higher agreed tariff. The magistrates court may not make such order. So I want you guys to also know that a magistrates court doesn't have the jurisdiction to make such orders, and that is captured in, I think it's Rule 48 of the magistrates court rules. High courts can give attorney own client, but it's also under extreme circumstances. The court should be unhappy with your behavior as a litigant, and also maybe to some extent that there's maybe lack of honesty, fraud, or to some extent something. But I think your readers covers it fairly well. They give you clear indication of what the court looks at. Now, what is cost the bonus proprius? And I touched on cost the bonus proprius. Cost the bonus proprius is a type of cost order that any court can um, dish out. So a magistrate's court can hand out a cost order de bonus proprius. Now, cost order de bonus proprius, it's a cost award of cost, but it's an extraordinary measure and means that the cost in the matter are to be paid by an attorney in his or her personal capacity. Now, guys, whoever cannot see the slides, please advise. Can everybody see the slides, or is it only some people? If some people can see the slides, and some can't, then it means that you have to log out and log in again. Because I see Sandra Yannick is saying, Sandy Lembele is saying they can see the slides. So please, Raima, and I think it is Latin, please just log in and out, and then you check if the slides appears. Okay. While our colleagues is logging in and out, I will try, and I see the session is being recorded, so I'll try and speak slowly so that if for some odd reason they could not see the slides, at least they can listen to my explanation. Now, as I said, cost the bonus proprius is an extraordinary measure that can be used in certain instances, and normally the attorney is paying for the costs in his or her personal capacity. Now, this thing has been stretched, and I touched on it yesterday. I say also a trustee, a court can also award cost the bonus proprius against a trustee of a trust, or a trustee in whatever, a liquidation of a company or something. Also liquidators, receivers and liquidators that handles with division of estates, but also an executor in his or her personal capacity. But recently, or not so recently, like around about 2016, 2017, there's also what they call the black sash cases. The black sash cases, and this is where the then Minister of Social Development, Batabile Dlamini, was ordered by court to actually pay some of the costs on a personal level. So this was the first time that the court actually ventured into that area to say cost the bonus proprius can even be stretched to that extent. And what the courts have now recently also done is with some of the police officers, and I think we saw now that brutality of the VIP protection unit from the deputy president. I think surely they are going to get that cost orders against them in their personal capacities, where the court will punish them in their representative capacities as police officers in fulfilling their duty. So recently our courts have been exercising sort of have a discretion to order particular litigants. So particular litigants would then mean these people in their personal capacity will then have to pay the cost of litigation personally when acting in a representative capacity as government officials. Now, back, people would always like just think, and these people were reckless in how they conducted themselves, in the sense that they know, even if you sue me, nothing is going to happen to me because I'm not the one footing the bill. Now, the legislation has not changed, but the court's approach to this has changed. So usually these costs would be payable by a state on behalf of such officials, but now the court is at that point where the court saying, you, sir, madam, you have now did 1, 2, 3, your conduct was unbecoming, and hence, although I'm making a cost order against the Minister of Police, they will pay a certain portion and you will pay a certain portion. However, to punish and this was sort of half a move by courts to punish the negligent and wasteful ways of litigation. Courts have now moved in that direction so that the official must pay costs personally. So just know that there is now these types of things that you can actually also get a person sort of half paying the normal fees or the fees in a matter. So just know that it's on the table, and if you working for a client in that regard, please advise them, listen here guys, this is a possibility. If the court finds that your behavior was unbecoming, they might give a cost order against you. So don't sit there idle Lexi Daisy and think nothing is going to happen to you. You are going to get a cost order and you will be responsible for the cost order. So these orders is based on negligence, and the court punishes the person with its displeasure regarding that person's conduct. So that's your cost, the bonus proprius. That is one of the cost orders that you can have. And obviously you guys can see here, I spoke about the Black Sash case. I will also, because I don't know if people can see it, but I'll also just post this case in the chat. So for in case somebody somehow cannot see the slides at this point in time, they'd be able to at least have the case that they can actually go look at, and this was specifically against the Minister of Social Development at that stage, Ms. Batabile Dlamini. So, Ms. what? Yeah, Batabile Dlamini, but I know it's Batabile Dlamini, yeah. She was the Minister then of Social Development. So, courts have now been moving in that direction, and now also if you act for the police, police officers in their personal capacity, because that's normally where our government gets sued the most. That's that department that's sued, that has the highest amount that has been sued. But there's also other people like trustees, liquidators, people in a representative capacity, who's acting in a representative capacity, and that's even you as legal practitioners can also fall prey to this type of cost order. So make sure when you deal with cost orders that you don't step into that trap. The next slide speaks to wasted cost. Now, wasted cost is just what it says. It's cost that has been wasted, and obviously one needs to determine who's responsible for the wasted cost. Now, generally speaking, if a matter does not proceed as set down in court on a particular day, the party responsible for the postponement of the matter will be liable for costs. Now, here is that topic that I touched on, granting of indulgence. They say the party responsible for the postponement of the matter will be liable for wasted costs. So when a court, because the general rule is that if you are bringing an application for indulgence, you don't necessarily get a cost order. But if the other party is responsible for you asking for that postponement, then it means that you are the party who's responsible for that postponement will then carry the wasted costs. So, for example, and here's it, if a respondent does not file his or her answering affidavit timeously, say, for instance, they file you serve a application on them for whatever it can be. You serve the notice of motion with founding affidavit on them, and the respondent then does not file answering affidavit timeously ahead of the hearing date. The matter might not be able to proceed on the set down date, depending on if you were able to actually take instruction from your client to actually do your answering. Not yet, the respondent fails to file its founding, answering, and replying affidavit. So then you won't have time to actually file your replying affidavit. So this means that the applicant will then, on the day of the hearing, actually ask for indulgence to get a postponement. But in this case, then the applicant can also ask that the respondent carries the cost, although they're asking for the application for indulgence. So here is the opposite of the general rule that says the applications for indulgence does not always give you the cost order as well. So in this instance, you can get, so this means that the applicant has then incurred wasted costs in preparing for the hearing, and the court will usually award such cost in his or her favor. So wasted costs is often agreed between parties in return for consent to adjourn or postpone matters. If a party is not ready to proceed with an opposed application or opposed matter, he or she might then request the other side's indulgence to agree to an adjournment, and in return, they will tender that side's wasted costs for preparing for the hearing. Now, what happened with me in 2012, after moving from Western Cape to Gauteng, to practice now in Gauteng, it was just at the time where also the borders, the regional court borders, was sort of adapted a little bit to fit in with the new regional courts that was given. And we somehow issued summons out of Palm Ridge Court on behalf of our clients. We issued summons out of Palm Ridge Court, only to find out that the matter actually resorts under the Johannesburg Regional Court. And we had to withdraw the matter, and we did so, withdraw it. But what we did not do is, like, we did not tender the wasted costs, which would normally happen. And that was an honest mistake by the attorney, that they did not tender the wasted cost. And for some odd reason, the defendant's attorneys at that stage did not also ask for the wasted cost, because in terms of the Magistrates Court Rules 27, 3, they could have asked within 60 days for us to pay the costs, the wasted costs for us withdrawing the matter, and because they had opposed already, they defended the matter already and stuff like that. So we didn't, and then more than 60 days has lapsed. Like after 4 months, they came back with an application in terms of 27.3 to say that we have to pay the costs. And then the attorney then advised them under my instruction that, listen, yeah, you have to actually withdraw this application because it's bad in law, because the Act says clearly you have to bring this application within 60 days. If not, you lose that opportunity to bring this application. And they persisted with the application, and we wrote them like, I think, 4 letters where we advised them on the law and asked them to go and look at the law pertaining to this, and they just failed. And eventually they set down the application, we filed our notice to oppose, we filed our answering affidavit, they filed a replying affidavit, and the file was ready. So on the morning that the matter was about to be heard, around about 8:30, they phoned us to say, listen, and we were already at court, waiting for the matter now to be called in roll call. And we were there, and they then said, okay, no, we are not going to proceed with this application because we now realize. And what did we do? We went in court and we actually asked for the wasted cost, but on that basis, we asked for wasted cost because the bonus proprius, because this was the lawyer that was negligent and his behavior was highly improper because we appointed him to the legislation and case law and he just failed to adhere to it. So in that instance, we sort of have made the lawyer pay the wasted cost on a cost the bonus proprius, although it was party, but it was cost the bonus proprius. So cost reserve or cost to stand over, what does it entail? Cost reserve or cost to stand over is when costs are reserved, the court only determines who is liable for the costs at the conclusion of the matter, when it will consider liability for cost in light of the matter as a whole. So cost reserve or stand over, it is then for later determination. It's important to remember that all costs that was reserved must be specifically unreserved before the court makes its final cost order. If not, you lose the chance and that cost can never be recovered. In the High Court, interim cost orders obviously will not be subject, because in the High Court, the court can also say that costs be reserved or costs stand over. But in the High Court, you have additional tools that you can ask. If there's an interim application or an interlocutory application, you can immediately ask the court to say, I want the cost to be taxed and payable immediately. Whilst in the magistrate's court, interim cost orders can only be taxed at the conclusion of the matter. So there you'll have to look at Rule 33, Sub-Rule 3 in the magistrate's court. But in the High Court, interim cost orders for interlocutory applications, it can be, you can ask the court to make an order that it's immediately taxable and payable by whoever is responsible for the cost of that application. So just remember, when you deal with reserved costs, that you also have that aspect to deal with. You have to unreserve it before the final order is made. But in High Court, you can also have costs, the cost be made payable and taxable immediately. Now, cost in the cause. What is cost in the cause? Cost in the cause, it is cost in the cause means that costs of interlocutory proceedings. So if you bring an application to compel another party to discover or give better discovery, or if there's maybe non-compliance with the court rules you bring, or maybe a rule, whatever it is, a Rule 43, if you're in the High Court, or Rule 58 if you're in the Match Court, then the interlocutory procedure, that cost for the interlocutory depends on the final outcome of the case. So you say cost in the cause, which is also something I don't like, but it can happen that the court says that, because the court will ultimately determine and look at the case as a whole and see, okay, and this will boil down to the successful party. It will stick to the general rule that if there's a cost in the cause order on interlocutory proceedings, it will mean that the general rule will apply. The successful party will be awarded costs. So if you can, you need to ask that the other party pays the cost, although it will be sort of have only be taxed and paid at the conclusion of the trial. So just remember, cost in the cause, that's what it entails. Other cost orders, cost of the day. This indicates cost occasioned by a party, and this cost of the day can also be sort of half in the same vein or same lane as wasted costs. Only obviously, if you get cost of the day, just make sure that you qualify certain costs, like maybe if you have witnesses that needed to come to court on that specific day, and the somehow the other party is now asking for a postponement. You have advocate that you briefed to actually appear on your behalf, that also be made part and parcel of the court order. That would include cost of the day. Maybe your candidate attorney was also some with you there. So that also the cost of the candidate attorney should also then be brought in. That's what cost of the day is, but you need to qualify certain aspects. Then we have all costs. All costs refers to a party and party cost order, unless the court indicates otherwise. Where the court say you we award all costs in favor of plaintiff, then we know it's on a party scale that the plaintiff is getting costs. But unless the court indicates otherwise, to maybe say plaintiff is entitled to all costs on an attorney-client scale, then it means something different. So you need to also, but if the court is silent, if the court is just saying the cost in favor, cost is given on all costs is given in favor of plaintiff, it means it's on a party scale. And then the one that nobody likes is if there's no order as to cost. Each party is then responsible for its own cost. So whoever instructed an attorney will have to pay that attorney, be it on party, attorney-client, or attorney-owned client. If there's agreements in place between the client and the legal representative, then you have to pay the legal representative as the agreement between the parties. So that you need to take cognizance of. That is the specific cost orders that the court can also grant. Obviously, no order as to cost. Where the High Court does not deal with a cost issue, a party may approach the court on a later stage on application for an order as to costs. But where the High Court orders no order as to costs, it means that each party must pay his or her own costs. Now, in the Magistrates Court, obviously, no order on interlocutory means actually cost in the cause. No order at all on cost. Application for variation can be brought. But if the Magistrates Court say no order as to cost, each party must pay his or her own cost. So there, the Magistrates Court and the High Court is similar. So I just want you, if you need to listen very carefully to the type of cost order, then you will know what other remedies. And I think this was I think Richard's question also, can you actually appeal against these types of costs? And that is where you would find the answer also, Richard. I think you asked that question specifically, if I'm not mistaken.
Yeah, that's correct.
Then you can actually go into that option to actually say, okay, if the court did not deal with cost, you bring that application so that there be a cost hearing, if one can put it that way, for the court to make such an order. So that is where you'd find the procedure pertaining to costs. So now there's also the aspect of settlement agreements. Now, obviously, and this was also, Richard, I'm sure this was also yours, that you also asked on settlement agreement, if parties actually asked on the settlement agreements. And I specifically said Rule 34 and Rule 27 makes provision where there's cost orders that you can actually approach court with a settlement agreement wherein you have now made sure that you capture the terms of agreement and what types of costs needs to be covered by the party in the settlement. So although they're settling on the claim amounts or whatever amounts that is in dispute, there's also say, okay, you'll pay 50,000 towards the plaintiff or the respondent or the defendant or the applicant's costs. So then you capture it in your settlement agreement. You make that settlement agreement an order of court. using those two rules in High Court, Rule 34, Match Court, Rule 27, Sub Rule 6, and then that settlement agreement, as part incorporated into the court order, has the same effect as if the court judicially exercised its discretion in awarding costs. So then you will then have that at your disposal, so that you can actually now say to the other party, listen, yeah, you have to actually now pay my costs, and that is the end of story, because that's what we have agreed upon. And you then need to now adhere to whatever the other party's cost demands is. And obviously, if another party fails to pay your costs, obviously, because it's now a court order, you know what you can do. You can now utilize the warrant of execution or emoluments attachment order, Section 65 proceedings. There is now various ways that you can actually execute a order, because it is now a court order. It's no longer just an agreement between, because the court has made it a court order, you then allowed to actually now go after the other party to say, listen, yeah, the court has made this order and you have to now pay according to the order, although it was captured in a settlement agreement. So that is how you would go with it. The issue on withdrawal of costs, and I told you guys already, this is the example where I said to you guys where we instituted from the wrong court, and then Magistrates Court Rule 27 was the rule that they used against us. But obviously, if you check the rule, it gives you 60 days in which you have to do it. It's similar in the High Court, that you have to, the party withdrawing must offer costs, but if not, then you can then force them using the application, but also know that it's not an application that remains open-ended for a long time. If you don't utilize that application within the right time, or the prescribed time limits as set out in the rules of court, you then lose that application, or the right to use that application against your opponent. So make sure, if that is on your table, that you actually can utilize it, and utilize it very quickly. Right, those settlement agreements, specific cost orders, I already touched on them, and it's usually on party scale. And obviously, when we talk about appeals now, specific cost orders, still cost of appeal. Now, from which point does the cost of appeal start? It starts from the notice of appeal. Doesn't matter where you are. If you're in district court and you are aggrieved, or your client is aggrieved by a judgment that was given against him or her, once they give you instructions to say, okay, send that notice of appeal, from the notice of appeal, that's where the cost of appeal starts. Qualifying expenses, make it part of your court order if you want to enforce it. So in expenses, and you can see the expenses incurred by a witness who has to qualify himself to be able to give expert witnesses, that has to make experiments, investigations, research, observations. Those are all expert witnesses that has to qualify themselves. Also, advocates' fees. You also need to make sure that you have the advocates' fees made part of the court order. Otherwise, you will also have difficulty in enforcing it. So a party awarded costs may recover his or her advocates' fees, given he has made it to be part of a court order. Now, as always, one must remember that the client will be liable to his or her attorney for all fees in accordance with the attorney's mandate. And this may include advocate's costs if you have spoken to your client to say, listen, yeah, for this matter, I think it's good that we bring advocate X or advocate Y on board, because this line of argument is something he specializes in, or this law, it's maritime law, it's a specialized field, he specializes in it, and I think he will be the best person to actually represent you in court in this matter, or to actually argue this case on your behalf, and then you can actually say, use it. So in the High Court, you'll use Rule 40. I say Rule 40. Rule 69 you'll use in the High Court. to actually make provision for that, and then you'll be able to deal with it. In the Magistrates Court, you will look at Magistrates Court Rule 33, Sub Rule 8, to actually make sure that you work with it. Obviously, the tariffs, how do you calculate the costs pertaining to advocates? You'll still look at the tariffs. So make sure that you check the tariffs at all times. So qualifying expenses, especially pertaining to expert evidence, there must be evidence of a technical nature. Now, I don't know how many of you guys actually followed the Senzo Mayiwa trial. Then there was a guy called Tabu Musiwa. He was the ballistics guy. So evidence of that nature would qualify as evidence of experts that you can actually make it a qualifying expert expense as per the court order that you might get. So that's just one example. There's so many others. Also, you get, maybe if you're doing motor vehicle accidents, you can get a accident reconstruction expert to come and actually give evidence pertaining to that. And you say to the court, this is an expert, he had to do certain things. His evidence is of a technical nature, and hence I want it to be specifically included in the court order, because we would not be able to get to a just and equitable verdict if we did not have the evidence of the expert available to us to actually guide us. So just remember, and there I just again say to you guys, where do you need to look for the fees? Obviously, the High Court rules has been amended, and I think the last amendment, according to me, was somewhere around July 2022, pertaining to costs. But there might be some that's coming, that's on the table as we speak now. So the Magistrates Court, obviously, the last amendment pertaining to the rules that I saw today again in the office, that we have some amendments that came in on Service 32. So, but the ones that came in operation somewhere around 24 August 2022, that also altered a little bit of the scales, but you can just check in the scales again to make sure that you are on point. That is just an example of what you look at, but I mean, the rules is clear. Now, in terms of your readers, then we would go over to a bill of cost. Now, what is a bill of cost? Why do we actually need a bill of cost? Why is it important? A bill of cost is sort of, for me, the backbone of a law firm. Because if you don't have a proper bill of costs in place, then you will run your firm into the ground. So a bill of costs is then based on a complete file and proper file administration. Proper administration and file administration is then of paramount importance. Now, I told you guys yesterday already that keeping your files in order, orderly, and making notes of everything, particular notes, so that you can actually justify an item on your bill of costs, is of utmost importance if you want to set up your account as concise as possible. So you need to make complete file notes at all times. Make sure your record keeping is up to date, because if you don't have a proper record system in your file, you will not be able to actually keep proper records. Then what that will mean is you will be able to actually recover certain of your costs, but not everything. Now, what is a bill of cost? A bill of cost is essentially an account that is itemized, and it lists all work, legal of nature, that you have done on behalf of client or as per the client's instruction. So a bill of costs sets out all the fees and disbursements incurred in fulfilling the client's mandate. So now a bill of costs is prepared once a court has made an order in terms of costs, when the matter is finalized. So the bill of costs is normally drafted by the successful parties, legal representative, candidate legal representative, or you can actually send it to a cost consultant, and they will do it in accordance with the cost order that was given. And then obviously one needs to check if there is also tariffs that's applicable to the cost order. Now, how to prepare a bill of cost? A bill of cost is prepared by perusing the file. Now, remember I said to you guys yesterday, I come from a school where I had the metal clip that we pierce from the first consultation, and after the consultation, maybe it's a telephone call. After the telephone call, it's a letter. After the letter, we start drafting summons with particulars of claim. Then we would just pierce the metal pin through the paper as per the things happening. My second part is where we have subfolders for different things. For telephone calls, for correspondence, and correspondence would be emails, fax, as well as normal letters by a post or registered post. Then we'll have file for clients' documents that we receive from client, office documents. Then you'll also have like maybe a portion for file notes. You'll have one for pleadings, notices, but that one means that you have to work with all the different subfolders when you draft the bill of cost. So you'll have to peruse very carefully. So the bill of cost is prepared by the legal practitioner, candidate legal practitioner, or cost consultant by perusing the client's file in a matter and recording each item, attendance, document drafted, pleading drafted, services performed, everything that is pertaining to furtherance and actually the actual adjudication on the client's file in a chronological sense. So that you start with consultation, telephone call, drafting of summons, drafting of particulars of claim, getting in, making copies. After making copies, you get into the car, you travel to court, you attend on issuing it. After issuing it, you'd most probably come back to the office to actually draft a letter to the relevant sheriff that has jurisdiction. If you are prudent, you would have had the letter already when you went to court to get it issued. So from the court, you'd go straight to the sheriff's office, deliver the document so that the sheriff can actually serve it on the other party. So that's how the bill of cost will also read. So it's then of utmost importance that you keep good records. So it's good reason why it's important to maintain up-to-date and comprehensive office files, because if not, your firm is going to lose money because there will be certain work that you've performed that you did not record on the court file or somewhere in the office documents. So each attendance in the bill of cost should be itemized, or each item on the bill of cost should be listed separately for ease of reference, and the charge in respect of each item. So each item, so you'll go, maybe you'll say date, item number, description, fee, disbursement. So you'll say, okay, telephone call made. Now we know in terms of the rules, maybe you are allowed 50 Rand per telephone call for 5 minutes or part thereof. So, okay, telephone call is 3 minutes, so 50 Rand is there, but there's also an actual expense on the telephone, what it actually costs you to utilize the Telkom landline to phone a MTN cell phone. Maybe that cost is maybe another 6 Rand 77. So that is the expense. The 50 Rand that you put on it is the time that you sell as a legal practitioner. So fees and disbursements must be kept separately in your bill of costs at all time. Then it also now which costs can be included in the bill of cost, and I think a bill of cost I did indicate to you guys, but I can also just sort of have just give you some of the things that I would normally sort of have in a bill of costs. I will put it in your chats for you guys so that you guys can also just use it as a guide. I'm not saying this is the alpha and the omega, but you can use it as a guide to actually look at what you can include in a bill of costs. So I've listed a couple of things there that you can actually include in a bill of costs when actually preparing your bill of costs. So make sure when you deal with the bill of costs that you look at the sort of list that I gave to you guys that you can actually include in the bill of costs. But as I said, it's not the alpha and the omega. It's important to remember that the client will generally not recover the actual legal fees incurred in a matter unless you get an attorney-owned client cost order, which we know now can only be attained in the High Court. Because in match court, there's tariffs that's applicable, and you can only get party and attorney-client, which we know doesn't necessarily cover everything. So the disbursements that you can get is normally like your advocate's fees, because advocate's fees on a bill of costs will go through as a disbursement, sheriff's fees, maybe your for utilizing your vehicle as a candidate attorney to travel to and from court, that is disbursements on the files. And that is how you, and obviously I said already, and I've spoken about this, who may actually prepare a bill of costs. Legal practitioners or candidate legal practitioners can prepare a bill of costs. It's often advisable to instruct a professional cost consultant to prepare your bill of costs, because they are experts in drafting these bill of costs, and also a bill of costs can be time consuming. But for me, I always say, as a candidate legal practitioner or a junior legal practitioner, it's always a good exercise for you to actually draft a bill of costs, so that you have a sense of what it is required to actually make money and actually have an effective practice, what needs to be in there, maintaining tidy and neat, well-organized files. Now, most of the cost consultants is also generally admitted legal practitioners who specialize in the law of costs. What we are doing, this legal cost, is actually called the law of costs. And they are experts, so they can actually do it better than some of us can do the bill of costs. So why not use them? And obviously, when they draft the bill of costs, the fee that they will charge you is the fee for drafting, or drawing is the word that they use for drawing the bill of costs. And it's normally a percentage of the total bill as their fee, or they will just take the drawing fee. So advocate's fees, we need to know it's an agreement between the attorney and the advocate. Lawyers, the legal practitioner is responsible, unless you have contingency fee agreements, and I already told you, make them party to that agreement if you don't want to have troubles. So that is how I would deal with the bill of cost. And a bill of cost, as I said to you, it's itemized. So you'll have like the structure of the bill of cost from left to right. It will be, you'll have the date, item number, then a description of the item that is on the bill of cost, the fee, and the disbursement column. So that is what you will include on the bill of cost. And we'll somehow, at some stage during the night, have a short exercise that I will give you guys in actually doing certain things. So the expenses that you'd normally find on the bill of costs, and I don't know how many of you guys have dealt with what they call substituted service, is where you can actually serve something on Facebook, Instagram, WhatsApp, Facebook, or in a newspaper on another person. But how that service works is that you get the order for substituted service, you send the documents to the sheriff in whose jurisdiction the plaintiff or the applicant resides, or it's doing business or running their practice or their principal place of business, and they will then serve it via Instagram, WhatsApp, Facebook, and you'll be responsible for all those costs. So traveling fees, subsistence fees, it's all allowed as disbursements on a bill of cost. So it will be the witness fees, be it a lay witness or expert witness, as long as it's qualified in terms of the order. Postage petties, and also your faxes and emails. But we know nowadays we've moved far away from postage or registered mail. It's like very seldom that we still use registered mail, because the ECTA Act or ECT Act allows us to also use electronic mail to actually send certain things, documents around. And in 2018, the Randburg Magistrates Court made a ruling that an SMS can also be seen as a document or as a letter. So you can even send a letter of demand via SMS to another party, and the court will say it's good. And that's also the cost of sending that SMS out will be seen as the disbursement that you can charge. So the writing part of writing the SMS, that will be a fee component. but the actual sending it out from a mobile device or a app that we have, like in your office, like Uniserver, to actually serve documents or messages via SMS, that costs of serving it via Uniserver or whatever it is will be the expense, the disbursement that you can attach to the account. So that is the bill of costs and how the format would look. So preparing it, then obviously things that you need to remember is that you need to keep a clean and tidy file at all times. You need to make notes on your file of all attendances, work that you have done, so that it be included in the bill of cost. And it's advisable, or I advise you, unless your practice is geared towards drafting of bill of cost, to instruct a cost consultant to prepare your bill of cost. But for you guys specifically, at least the first 5 files where you get a cost order in your favor, try and draft it yourself, so that you just get that sense and that feeling of what it is to actually draft a bill of cost. That would be my advice that I would give to you guys at any given day, to actually just do that, so that you have sort of half an idea of how to actually sort of work with it and actually gets it in order and makes it works for you as a practice, so that you can actually sort of in future know exactly why it's important that you actually should be fighting for a bill of cost. So then the next thing that your readers would go to, but for me it is sort of, yeah, I'll go according to your readers. It's an allocator. Now an allocator or allocator. Now here you'll see on my slides we talk about the taxation, and I just want to see the slide that deals with the allocator, because normally I would put it at the end. Now the allocator or allocator, or the grand total or total allowable fees, what is this? And you can only get to the allocator if you've done the taxation. Now the allocator is normally prepared at the end. So if you haven't done the taxation, then you can't get to the allocator. Now, what is an allocator? I will just give you a brief rundown, then I will go back to my slide dealing with the taxation, because I need to first tell you about certain things before you can actually get to the allocator. Now, allocator or total allowable fees is contained at the foot of a bill of costs, where the final total of the bill of costs is calculated. Now, there's various ways of calculating it, or not various ways. There's a way of specifically calculating. It's a little bit different for the High Court and Match Court, but the bulk of the principle remains the same. Now, so the allocator is calculated as follows. The amounts taxed off by the taxing master are deducted from the fees and the disbursements component to obtain a subtotal. Thereafter, a drawing fee is added to the totals. A drawing fee of 10% was the old, a drawing fee of 11% in the High Court is added, and also a drawing fee of 11% in the Magistrates Court can be added to the total allowable costs. So an attendance fee is also allowed in the High Court, and it can be added to the total allowable cost as follows. So attendance fees in both Magistrates Court and High Court works on a sliding scale. 11% on the first 10,000, 6% on the second 10,000, and then 3% on the remainder of the bill. So that is what I'm going to say about an allocator. And now I will venture back. I will go back to the slides on top to speak about taxation. Why is it important that I actually speak about this taxation thing? Because I want to draw your attention to the following aspects. In terms of the High Court rule, Rule 70, if 20% of the items is taxed off your bill of cost. 20% of the items, which means then they would look at if 20% of the fees and the disbursements is taxed off, then you will not get your attendance fee. So just remember that in the High Court, if 20% of your amount is taxed off, you will not get the attendance fee. So the attendance fee is for you to actually appear at the taxation and then get those costs. In the magistrate's court, if 25% of your fees is taxed off. So here you can hear, I said 20% in the High Court of your fees and disbursements. If 20% is taxed off. Now, what lies in this High Court thing? If you have a big disbursement and it's taxed off, it can most probably take a bulk of that 20% that you are allowed, that leeway that you have to have. So it's literally your account can be wrong by at least 20%, and you still would be getting your attendance fee. If more than 20% is taxed off, you know already you are dead. In the magistrate's court, if 25% of the fees, so the penalties that's applicable to the magistrate's court is 25% of the fees. If 25% of the fees is taxed off, then you know, okay, I'm still good to go. So you will see here, match court, it's rule 18 that is applicable on the fee component that can be taxed off. So make sure at all times that you work out. So the remuneration of an attorney referred to in your bill of costs. If more than 20% of the number of items on the bill of costs is taxed off, then you know you've got problems. If you in the magistrate's court, if you have 1/4, the act refers to a 1/4 in 13/18. So 13/18, if that is taxed off, if a quarter is taxed off or 25% is taxed off, you've got a problem. So cost for taxation means that cost for attending, and that sliding scale, 11%, 6%, 3%. So just remember, if more than 20% of the items is taxed off your bill of costs in the High Court, you are dead. 25% of the fees in match court, you are dead. Is everybody clear on that? Everybody understands what that entails? Everybody understand what that entails? Now, before I venture into new things, I also have something that I need to sort of share with you guys. And I would now ask you guys to look at the screen. I will stop sharing the slides quickly, but we'll get back to the slides quickly. I will stop sharing the slides and then I will give you something else. Now I'm sharing something else. And I'm saying my windows and I want to see where is the class example. That is okay. Can everybody see the slide? I just need an indication. I see there's a hand up from Sandile or Quintus Dirks. Your hand is up. If you guys can.
Sorry, that was a mistake, but we can see, yes.
Okay. Now, given what I told you guys now, I say, okay, this is your bill of costs. You've drafted your bill of costs. You as the legal practitioner or candidate legal practitioner, you've drafted your bill of costs, and your bill of costs runs to 50,000 Rand that you're going to ask your client. The disbursements on the account that you've tallied up, it goes to 12,000 Rand. And you were so good. You guys are such good candidate legal practitioners. The taxing master could not text off nothing from your account. Nothing. You guys are super. And I say, okay, now that is where the total sits. I say, can you work out the allocator for me? Obviously, you guys will see there's the totals I show you.
Hello.
There's the totals. And I say, can you work out the allocator for me?
Pushe, check your WhatsApp.
I don't know who's warning who, but we could hear that people are warning the others to check the WhatsApp. Miranda say, can we see the slide? Miranda, which slide do you want to see? Motolo, which slide do you want to see? But I hope you guys can see the exercise that I put on the board. The exercise would be the example where I say it's below. So you guys can see that one where I give you the total of 50,000, and the 50,000, I can go as far on top here to say, let me see if I can put in some line here. But the 50,000 here, that is the fees, and the 12,000 is the disbursements. Now I say to you guys, work out, and I will just scroll down, but I'll show the totals again to say, I want you to work out this grand total. This grand total here, you can also call it the allocator, or another name is total fees allowable. So that names can be used interchangeably. So it's up to you what you want to use or call it. It's interchangeable, so it's not a catch-22 situation, but I will just go up, and this is now in the Magistrates and High Court, what is transpiring after the rule changes. So I say now, I've sort of have spoon feed you guys a little bit here, but I just want to see if you guys can actually catch how to actually draft this thing. Okay. So are you guys comfortable with this one? Okay, so everybody's I see there's a mic on. Just switch your mic on before we hear, and I'll check Instagram again. Miranda, your mic is on. Okay, guys, now it is 6:32. I will give you guys at least, let me say, 15 minutes to complete this. I don't know if it's a good time to actually give you, because some will be struggling. Or let me say it's now 6:32. I'll give you till say 6:50 to complete it. Then you guys must give me your answers. I give you till 6:50 to complete the allocator. 6:50 to complete the allocator. So guys, use your calculators. Make sure whatever calculation you make, write it down on a piece of paper so that you don't forget it, so that you can actually go into that format and have all the totals, because it's a lot of adding and subtracting, dividing, making sure that you get it right. And obviously, please make sure that you also know the rules. I told you, uniform rules 70 sub rule 3 and 4. You need to check there if you're not sure as to what you need to be doing. And then rule 33 from 17, 18, but 18 is more specifically applicable to you guys. So make sure that you check. Okay, I'll leave you guys now in peace till 6:50 so that you can do this.
Sorry, Prof. Could you please just scroll up there?
Okay, I will go to the one that says below. So you want me to go like this? Is that okay, Quintus?
No, the other way, please.
Or down?
Yes,
Like
thank
have
you.
the subtotal down.
Yes, thank you.
Okay, so guys, you guys have the top part. Let me just capture. You've got the top part, so I will sort of half scroll a little bit down so that you literally know there's the grand total, and that's what it is. So I'm giving, this is like a giveaway. They will not give it to you like this in the test, but I'm giving it so that you know exactly how you're going to actually do it or not do it, what you need to include or not include. So make sure you get it right at all times.
Could you scroll out ever so slightly just so we can see the whole thing on one page?
Okay, I will try and do this.
Or the top column there, if you just click on it so that that home can just disappear where you've got your font and that kind of thing.
Okay, let me just do this. Is that okay?
Yes, thank you.
Much better.
100%. Okay, I'll leave you guys now till, because I think I already stole 5 minutes of yours now. Okay. I hope we are sort of back. And I see that people has posted answers. I see there's an unknown user of 79161.22. There's one Vanessa Voort has put 79073.25. Rihanna Kruger has put on 66.815 and then 16.721. I don't know what that means, Rihanna, but okay. Sandra was helping out a friend with information there. I see Tatejo is saying 79418.75. LDV Smith gives a 79418.75. So LDV and Tatejo is like at Idem. Then I see Ms. Klassen is coming through at 8697, 4.50. There's a Bonolo Bopapi is at 89187. Then Christo is at Idem with Tatejo and Smith. Then I see Veronica Shezi is at 7841,250. Guys, can we get, I will give another 1 minute, just like a little 1 minute, so that you guys, guys, and it doesn't help if you don't work it out, because then you will never understand how it actually works. And in the exams for legal costs, they are going to ask you to work these things out. And the funny part of it is that they might give you one that has some tricks in it, and you will not know how to work it out. VT or VTR is worked out on 75. Herman Theo van Eden, it's 67. I see Michelle, I don't see anything of you. Have you posted already? Farzana Abdul Ahmed is at 79,350. I see Farzana doesn't want to work with cents. She just wants to work with round numbers. She said her practice is round numbers. MP is at 74. Adam Bardenhorst is at 79,418.75. Shaolin Harikaran is at 79,418. So she's sort of half agreeing with Christo, Smith, and Tatejo. I'm not saying Smith, Tatejo, and Christo's answer is right. I'm just seeing where there's similarities. Unknown users coming through at 46,766.13. Then I have a 79,418, which is also for Wendy Manuel. Then also unknown user. So Christo Mokone is at the 52,550. So guys, I'm getting a whole bunch of varying answers. So I'll give, I see Victoria Bota came in at the 69 and Kanya Kasana at the 51. So there's various answers, which means that there's certain things that sort of is somewhere in your mind there. Richard, I haven't seen your answer, and I know sometimes you've got good material to bring. Quintus also, I didn't see you yet. Are you still busy, Quintus?
I'm so busy. It's Friday evening.
So okay, I understand, Richard. I understand the brain is a little bit like sort of in a relaxed mode.
Today's
Okay.
Friday.
Rahima Ahmed Bashir is 71,315. There's an unknown user at 79. Sibongile Shoreya is at 79,401. So I see a lot of people is getting to 74,418.75 now, give or take. Cora van der Merwe, Cora is also at 79,418. Michelle, are you still battling there? Yeah, because some of the guys, I can't see your names. I just see unknown user. Then I see Josetta Pema is also at 79,418.75. Tabang is at 75,100. Mabuza. Kaba Sonwabile Kaba is at 7170. Kaba, you really lenient on this client here. Michelle is throwing in a 81,678.75. Baba, you love your client. I see. Maybe you supposed to work pro bono. You really love that client, or maybe it's a family. You got a family discount there. Okay. Okay. Now I will open up the answer. Now I see there's still some. Jacob Modizet came in at 8284. So I will stop sharing the example so you guys can see. Then I will go now to sharing screens, and then I will say I'm looking for a class example where the answer is below. Can you guys see the example now? Okay, and I need to do again the closing of the ribbon, and also to just sort of have close in on the total. Okay, it seems that I'm agreeing with those 79,418.75. Tatejo, Smith, Cora, Christo. There was a whole host of others that also got it. Is that how you guys actually worked it out? This is the time where you guys need to ask the question now to say, listen, yeah, why did you do 1, 2, 3? I will give like 5 minutes of quickly questions, then I'll explain it, because there's something else that I need to show you guys as well, so that you guys are comfortable in dealing with the various situations that you might encounter in the exam, because they will definitely give you something like this, because they normally give like you to actually work out this in the exam. So is everybody clear on how I calculated it? Everybody clear on this? There's not a shadow of a doubt as to what I did, how I got to that conclusion, why I'm making this. Is everybody with me? If I get, can I get the thumbs up there? If you guys, I see that somebody's hand is up. There's 2 people.
Foreign sir, you
Leslie.
speak to Leslie.
Yes, Leslie.
Hi sir, I was having terrible connection like this whole time, but I see you guys are on an explanation here and you're giving answers already. If it's not too much trouble, could you just repeat it like very lightly, sir? So I'm just in the loop as well, please. Or will this recording be uploaded?
The recording will be uploaded because it's being recorded. So the fact that you are already part of the group, you'll be able to see the recording. But I was just explaining to the penalty clauses that kicks in to say, okay, in the High Court, if 20% of your fees and disbursements is taxed off, you're not getting an attendance fee. In the Magistrates Court, if 25% of your fees, excluding the disbursements or excluding the expenses, is taxed off, you're not getting a cost for attendance of the taxation. So I said, there's the penalty clauses, and I draw the attention to Rule 70 as well as Rule 33. But also you need to look at in Rule 33, you'll read it with the Annexure 2 that speaks to cost and fees, specifically under Part 4, other matters, and taxation is one of them. Then they set out what you can and cannot get in the taxation. Wheaty, I see your hand is up.
Good evening, Advocate.
Good evening.
I have a problem with the last one where it says attending taxation at 3% on the remainder of the bill.
So is
so which count?
Where it dropped you off? Is that where it dropped you off?
Yes, that's where it dropped me off.
Okay, I will attend to that. I will just hear what Notando has to say and Charley, what they have to say, and then I will actually explain from top to bottom again what transpired there. Nontando,
Okay, thank you.
Nontando, can you also,
I wanted to ask the same thing. How did you work out the calculations?
okay, I'll come back to that. So Nontando is off.
Okay.
Shalay Marie,
Good evening, Advocate. I just want to find out, why do you add the disbursements and then subtract it again and then add it again?
okay. Now it's fine. I will also explain that. Richard, I see your hand is up.
Yeah, I've got the same question as the previous speaker there. I also added, and that's where I went wrong. But the adding and then subtracting it on the
Okay.
disbursement. So that's also that's where I went wrong.
There was a reason I wanted to catch you guys out. I was economical on the information because I wanted to use it as a teaching moment so that I can actually teach you guys so that you guys will never ever step in that trap again. Libakiso Jela.
I also had the same question about the 3% remainder of the bill.
Okay, 100%. Guys, I will go now to the slide and then I will explain what is transpiring there. What is happening on the slide. So I'll try and make it a little bit bigger so that it's still there. Okay, guys, now I said to you guys, okay, the fees component is 50%, 50,000. The disbursements is 12,000. And technically here, if there's nothing in that column, it's actually zeros. So there's nothing text off. And remember, I sort of have praised you guys, say you guys are a good group and you got this bill spot on. You have nothing text off. Just somebody's mic, can you just mute there? Somebody's mic is on. I think it's Leslie. Can you just sorry, yeah, thank you, Leslie. Okay, so you guys got it spot on that nothing got text off your bill of costs. So now the next thing is now drawing fees. Now remember I said drawing fee is charged on the attorney's fees. And in terms of the rules also, if you go look at rule 70 sub rule 3, drawing fee is charged on the fees, on the attorney's fees. Also, if you look at 3318, drawing fees on the fees of the attorneys that you look at. You look at the attorney's fee, a drawing fee. And also if you look under annex scale of cost, annex 2 scale of cost, part 4, it will tell you there is taxation and it's item number 6 for drawing the bill of costs, making the necessary copies and attending settlement. 11% of the attorney's fees either as charged in the bill, if not taxed, or as allowed on taxation. So 11% of the attorney's fees. So what is the attorney's fees? Is the 50,000 rand. So both the drawing fees in High Court and Magistrates Court is calculated on the fee part. You leave alone the disbursement part. Now we go over to the, now we have the attorney's drawing fee. Now we say 50,000 plus the, and if we say 11% of 50,000, then we surely need to get to the 5,500 rand. Is everybody understand how to get 5,000? So you say 50,000 multiplied by 11 divided by 100. Then you'll get the 5,500 and you'll add 50,000 to that. And you get your subtotal there of 55,580. Now taxation on the other end. Taxation, it's a different ballgame altogether. To say now attending taxation, in addition to the fees charged in terms of the drawing fee, if recourse is had to taxation, if you had to go to taxation and obtaining an order or a taxing master's thing, taxing master's endorsement, you can then charge 11% on the first test 10,000 or portion thereof, 6% on the second 10,000 or portion, and 3% on the balance of the total amount on the bill. Now, what will the total amount on the bill be? It will be then the fee component less the amount taxed off. You get to the subtotal plus the drawing fee plus the disbursement, because that will be the total amount of the bill. So hence we have to now add the 12,000. We have to add the disbursement so that we get the total amount of the bill, and then we work out our 11%, our 6%, and our 3%. Now, guys, if you are allowed taxation, if the penalty clause did not kick in, be it in match court or high court, be it, because here nothing was taxed off, so you are not hit by the penalty clause. Nothing has been taxed off. So attending taxation, be it in a high court or in magistrate's court, if you are allowed taxation costs, the penalty clauses is not kicked in, then that attending taxation 11% on the first 10,000, so it will always be that amount, 1,100 rand, if the penalty clauses doesn't kick in. Then the second one is attending taxation 6% on the second 10,000 will always be 600 rand. So those two amounts, if the penalty clauses doesn't kick in, it will remain on your bill of course. You don't even need to work it out. It will be there. 11% of 10,000 doesn't matter if you're in high court or in match court, it will be 1,100. 6% of the second 1,000 doesn't matter high court or match court, it will remain 600 rand. The part that is variable, that will change, is that remainder on the bill. Because depending on what your subtotal is after you've added the fees, the drawing fee plus this disbursement may be different in different scenarios. So now you say 67,500 minus the first 10,000 because we have the amount already. So you are at 57,500 minus the second 10,000 because you have the 600. So we are on 47,000. So the 3% on the remainder of the bill will be 3% of 47,500. Now let's see. If we take 47,500, you multiply by 3, divide by 100, what do you get? Voila, 1,425 rand. So that is what it is. Then you tally it up. So you'll say 67,500 plus 1,100 plus 600 plus the 1,425 rand. Then you should get a new total of 70,625 rand. That is the subtotal. Now here I say, after the 70,625, subtract the disbursements. Now some of your questions is, why do you subtract the disbursements? Why do I subtract the disbursements? Because in practice, disbursements, like your sheriff's fees, the sheriff's is vet vendors. The petrol that you put in your car at the petrol station is a vet vendor. So in that 12,000, there's already vet that is included in that disbursements amount. If I'm going to leave it on there, then I will charge vet on vet to the client. So the reasoning why we take it off is because the disbursement amount already has vet in. So then we say 70,625 rand minus the 12,000, which lands us on 58,625 rand. That's the amount excluding disbursements. The reason why, because disbursements has a VAT component that's already captured in it. Now we work out VAT on 58,625%. Guys, and here's also where they can catch you. You need to read your question. You need to check what does the examiner ask of you. Because the examiner can say, in this example, yes, you need to work out the VAT, but we charge VAT at 7%. It's only when they don't give you the VAT rate, then we go back to the default VAT rate in South Africa, which is 15%. If they give you the VAT rate in the question, you use the VAT rate that they give you. If they don't give you, we go to the default VAT rate. In this scenario, I did not tell you what the VAT rate should be, so you kick to the default VAT rate. So what is VAT of 58,625? What is 15% of that? So you say 58,625 multiplied by 15 divided by 100, and you get the amount of 80. 793.75. Am I correct? I should
Yes,
be.
correct.
100%.
Yes.
So then we say, okay, now to get to the grand total, now we've worked out the VAT. We know now the subtotal before VAT was 58,625. So we says 58,625 plus the VAT. But now we need to remember we took out the disbursement, but the disbursements forms part of the total amount for the bill. So then we add the disbursements back in because we already worked out the VAT. And if we add the three totals now, the 58,625 plus the 8793.75 plus the 12,000 rand, we get to the grand total, which we can also call the allocator or allocator, whatever you want to pronounce it. So that is what it is. So that is how you will work it out. Is everybody with me? Did I go slow enough so that everybody catch? So I'm glad everybody's with me. I just see you guys are with me. Now, guys, now here is now, okay, now I'm going to say, watch now what I'm going to share with you guys now. Okay, I've penalty clauses. I've now dealt with the penalty clauses, and I'd say to you, okay. And obviously, when you present a bill of costs is first presented to your opponents, and you give them 10 days to inspect any documents relevant to the bill of costs. And thereafter, after the expiry of 10 days, they will have another 10 days to file a notice to oppose the taxation, listing each item which is opposed and stating the reason why that item is opposed. Now, guys, in your readers, I've picked up a mistake in your readers. In your readers, when it comes to the penalty clauses, and I just want to see where's your penalty clauses in your readers, because I know I've seen the mistake in your readers. It's on page 69 in your readers. Please make a note there, because in your readers, it will read as follows on page 69. Which are excessively high, deny the attorney the remuneration referred to in item 1 and 2 of this section, drawing fee. So if more than 20% of the number of items in the bill of costs, excluding expenses, or the total amount of the bill of costs, including expenses. So it's never excluding expenses. It's always including. So if more than 20% of the number of items in the bill of costs, then you scratch out that amount or you scratch out the sentence that says excluding expenses or the total amount of the bill of costs is text off. If 20%, it must read if more than 20% of the number of items on the bill of costs, including expenses, is text off. So the part where it starts with excluding expenses until that part where it ends with bill of costs just before including expenses, just scratch it out, because that's not what's in the rules of court. Karabo, I just want you guys to attend to your reader. Please just scratch that part that says excluding expenses until there by bill of costs, so that it reads bill of costs including expenses is text off.
Yes. Sorry, Advocate, I'm sorry to take you back. I just had a little bit of a question. On the calculation, right? I just need you to confirm, because I'm sorry, maybe my numbers are just defeating me. The 3%, it says
Yes.
attending a taxation 3% on the remainder of the bill. What amount are you using for the remainder of the bill? The 67,500?
You say 67,000 minus 20,000, because there's a first 10,000 that you calculate 11% on.
Perfect.
And then there's a second 10,000 that you calculate 6% on. So automatically the remainder of the bill must be less 20%. Less 20,000, sorry, not 20%, less 20,000. So it's always going to be like that. So whatever your bill is, if your bill is 100,000, you'll take off the remainder of the bill will be 80,000. If your bill is 150,000, the remainder of the bill will be 130,000, the 3% that you'll calculate on. Caroline, I see you say which page 69. I don't know if my readers and your reader is the same, but on my reader that I have from Lead, it says page 69. It's on page 69, but I'll say to you, it's under penalties, 9.6 in the reader. It's 9.6 in the reader. It's 9.6 in the reader. So please check it if your reader is the same. 9.6, just check for me. Mankope Malebai.
Hi,
Mankope
Prof.
Malebai.
Point 9.6 is correct in the reader. But my question relates to the VAT on the fees, the drawing fees, and the attendance fees. I see when we did the calculation, we didn't need to specify those values in our calculation. But I'm assuming in an exam, we would be required to do so. Is that correct?
So that you show on each item, what is the VAT on each item?
Correct. So in our calculation, the subtotal before we did the VAT was 58,625. And what you did instead was to say the 58,625 divided by 15 times 100, which is VAT in itself. But I worked it out where I worked out the VAT on the fees exactly, which came to 7,500, the drawing fee 825, etc., separate amounts, and I added those together along with the subtotal of 58 to get that 79,418.75.
That you can, Mankope, you can also use that way. It will give you the very same thing. It just, you need to just check what the examiner is asking you. If they say calculate VAT on fees only, then you would like sort of make the drawing fee alone, attendance fee alone, and then the fee component alone also. Then you can untie them. But if they don't say, you can just do them together and go through with it. Ria Betswe.
Thank you so much. I just wanted clarity. Clarity on something. I understand why we take out the disbursements when we are calculating VAT, because that is a component that's already included by the other service providers. I want to understand what is the principle that governs why we can use the attending tax on that 12,000 and not, okay, I understand why not for VAT, but why are we able to tax on that 12,000 on the disbursements? What's the principle for that?
But remember, the rules allow you, the rule says, and I went to specifically to say rule 70 sub rule 3 and 4, if you read it nicely, it will say on the disbursements, you are allowed a cost for taxation on the total bill. On the total bill, and total bill would include the disbursements. So if you look at rule 70 sub rule 3 and also under annexure 2 for cost and fees in your magistrates court rules, it says on the total bill. So you are allowed taxation on the total bill. So the total bill would include, it should include, because legal cost comprises of two things that I said yesterday. It's fees and disbursements. The only thing that you need to do, you need to qualify your disbursements. Richard?
Thank you, Prof. This calculations took me way back to my BCom law days. What I want to find out from you is, and I think that's also where I went wrong, because I just grabbed my phone here to do the calculation. In the exams, we may use the scientific calculators.
Yes.
Okay.
Then you can just leave the numbers in the calculator. You don't even need to take them in and out. But if you don't have a scientific calculator, then I would suggest you write them down so that you don't forget the subtotals, so that you don't need to work them out again over and over.
Yeah, that's where the time went with me. Thanks.
Yeah, 100%. And obviously, they will allow you with legal costs. They do allow you to bring a calculator in the exam. Okay. Now I want you guys to actually now watch the screen, and I will share something additional now. I need to just find it. Now here, I have something for you guys to do. Now I will give you guys another. Now here, you guys have got now the gist. This is a straight example. I will make it smaller now so that it fits the page. And you guys can see it. I will make it smaller. So there it is. Your fees component is 150,000. Your disbursement is 200,000. And for argument's sake, I'll be nice and say, okay, on the disbursements, nothing was taxed off. And I say now, please, now I give you less time. So I give you now till say 8:32, because now it's 7:22. I give you to 8:32 to work it out, because now I've given an explanation and I want you now to move quicker, so you can actually move much quicker on this one now. So there you guys have it.
Sorry, advocate, you're giving us until 8:32. It's 9:22 now. So like an hour.
No, sorry. I said 8:32, 19:32. Sorry. Thank you for, thank you, Quintus. Thank you. Not so long. I'm giving you 10 minutes. 10 minutes, because now I've given you 20 minutes on the previous one, but now this is run of the mill, because it's now the next example. You're supposed to get this quicker. I just changed the figures. So it should be quicker for you guys. So until 27:32, then you guys need to give me the grand total or the allocator.
Pardon, lecturer.
Yes, is it
Hello?
Leslie? Yes, Leslie.
Hi, sir. I'm not sure if you are showing something on the screen, but if you're not, can you just please repeat those numbers, please?
I'm showing something
for
on
the
the screen.
example.
I don't know if you can see the screen, but the
Oh, sorry,
total.
so I'll just log in and upload it.
Okay, just log in and out. It's on the screen. I will leave it on the screen. Okay, I'll move the minute to say 19:33. I'll move the minute to 19:33. 19:33. Okay. Can I get the answers there? Can I get the answers there? Can I get the answers there for the group? Can you post for me the answer so that I can see what you guys were up to? Let me see the chat. Let me see what's coming through there. I see answers like 3340 and 3305, 346, 323. So there's various answers that rocks up here. Now, guys, without saying whose answer is correct, I see actually who went. Cora went nicely and actually sort of made even a table of how she got to her fees. Guys, is everybody in? I'm seeing I will give another minute. I just give another Windy, Rihanna, unknown user, Adam is coming through. I wonder where's Tatejo. Tatejo, I didn't see your answer. I was trying to look. Tatejo and LDV Smith and Crystal, because you guys sort of came in very quickly with an answer on the previous occasion. Quintus was quick this time around. I see Quintus was in with an answer. Renele, I see you've got an answer, is what she got. Renele said 346 or 346,218.48 is what I got. That's what she got. She's qualifying it. And then I see unknown user got the same. And that's Quintus is apologized for his answer. He typed it sort of half the comma wrong. Then I see Sandra, it's coming in with 346,200. There's a lot of 346,218.48. Baranas, Farzana also came with a 321,846.525. And then Fumani is at 352,081.85. Jaffa is at 346,218.48. Then Shasha De Beer is also at 346,218. Ritsokopa is also Rachikopa is also at 346,218.48. I see that is the answer that more or less features the most in your answers, and I see LDV Smith just said sorry 0.48, so his answer is most probably making it the 0.48. Victoria, now I will go and then I will say stop sharing that screen, and then I will share now a screen where it says the answer. Can you guys see my screen with the answer? If yes, please give an indication.
Not yet.
Oh,
Not yet,
No.
Advocate.
You guys can't
Nothing.
see.
No,
You guys can't
not
see.
yet.
Okay, I'm going to share. Okay, I will share now. I will share now. Just give me a minute. I just need to look at the document's name again. Class example, answer. Class example, answer. Class example, answer. Where's my answer now? I need to get it. Class example, allocate your answer. It should be appearing now. It should be appearing now. And how many is kicking themselves?
Yes, it's visible.
How many is kicking themselves now?
It's visible.
Is it visible? Marcus, how many of you guys are kicking yourself now?
Me. Oh, I got
Me,
three
sir.
T.
All of us.
Me
How
as
many of you
well.
guys are kicking yourself?
word.
No,
But can you guys see
check it
what
out.
you guys, I was emphasizing something and you guys all missed it. And this is
You
what the
really
examiners
got
will
us
do to
out
you.
there.
The examiners will hit you guys because remember I said It doesn't matter in which court you are. You look at, is my penalty clause kicking in? That's your first go-to. When you have to work out the allocation, you say to yourself, is my penalty clause going to kick in? If I'm in magistrate's court, is 25% of my fees taxed off? Yeah, I give you the total that has been taxed off is 45,000. And if you work it out in match court, if you say 45 divided by 150, then you get something like, what is it? It's 30%. It's 30%. So doesn't matter if you're in high court or in match court. Doesn't matter if you're in high court or match court. You are hit by that penalty clauses. So your penalty clause kicks in. So when the penalty clause kicks in, what are you not entitled to? Can everybody see? When the penalty clause doesn't kick in, you are not entitled. You don't get your attendance fees. So your 11% becomes 0, your 6% becomes 0, your 3% becomes 0. You're still entitled to your drawing fee because it's still the work that you have to perform to draft the bill of costs. It's work, it's time that you use out of your practice so that they don't deny you. But sometimes you get conniving taxing masters that they will even take off your drawing fee if your account is so badly drafted, because they have a discretion to also mess with the drawing fee. But most of the time they will allow you the drawing fee. But what you should know and ought to have known is that my penalty clause has kicked in. And once your penalty clause kicks in, once you get to that subtotal of 316,550, you just need to take out the disbursements and work out your VAT and then get your subtotals, add the VAT, the disbursement, and there you go. That's why I even gave you. So if it's 25% or less, 25% or less, you get the drawing fee if you are in the magistrate's court. If it's 20% or less of the fees component and the disbursement component, if in high court, if it's 20% or less of the fees or disbursement component that's taxed off, you still get it. 20.00001 penalty clause kicks in. 25.0001 penalty clause kicks in. So obviously, when I'm giving or the examiner gives you the text of amount, work out to just in your mind know my penalty clause doesn't kick in or my penalty clause kicks in. So I don't need to worry about my taxation. If it kicks in, I don't need to worry about the taxation. If it doesn't kick in, I can then work out my figures. Then I know my first 11% on the 10,000 will be 1,100. My second 6% on the second 10,000 will be 600. The remainder of the bill. And let's say for argument's sake, yeah, the penalty clause did not kick in. So then we would have said 316,550 minus 20,000. So you say 316,550 minus 20,000 will give you 296,550. You'll work out 3% of that if the penalty clause did not kick in. And you'll say multiplied by 3 divided by 100. And you will see that your attendance fee for the 3% on the remainder of the bill would have been 8,896 rand and 50 cents. But that's only if the penalty clause did not kick in. I see one's hand is up. Chalet Marie.
Hi, sir.
And then Cora's hand.
So if the text of amount was, say, for instance, 10,000 rand, then you could have still add the attending taxation.
Yes, because then 10% that was taxed off is not more than 25% or 20%, irrespective in the code that you operate in.
Okay, so for instance, in the examination, they will say text off, or will they just give the amount and you have to see, okay, it's more than 20.
They will say to you, maybe, they will say to you 45% of the fees has been taxed off. They will give you that amount. They most probably would give you the total as is. They will give you the total and text of amount, and then you have to work out the subtotal from here. You'll have to work it out. They will give you that that amounts here. And for all intents and purposes, we know from the example that one is 0. So that they will give to you. That they will give to you this blocks here. This blocks here, they will give to you. The rest you'll have to work out. You just need to check, is my penalty clause in or not? Cora and then Witty.
Thank you, Advocate.
Advocate, you mentioned something about working out the percentage, whether it's more than 20% or not. You said it's 150,000 divided by what?
So here, in this example, it will be 45,000 divided by 150,000. Then you'll get the decimal of 0.3 multiplied by 100. Then you see the percentage.
Okay, all right. Thank you.
Cora?
Please repeat that. I didn't get it, please.
I'll come now, Nontando. I'll just give Cora quickly a chance to speak, and then I'll come to repeat what I said now.
Mr. Hart, the Magistrates Court rules are clear. If you tax off more than 25%, the taxing master of the fees, the taxing master may not allow a taxation fee or a drafting fee. So, and they do not have a discretion in those circumstances. So it applies to both the drafting and the taxation fee in the Magistrates Court. But in the High Court, the rule reads as follows. The taxing officer may, if she's satisfied that the requirements has not been complied, that is, if you do not have a certificate, or she's satisfied the fees being charged on a party and party bill for work not done, and more than 20% of the number or the items in the bill being taxed off, then she may refuse a taxation and attendance fee. So the difficulty now is, or not the difficulty, actually it is a difficulty because the different divisions of the High Court in South Africa applies it differently. You will never ever get in Pretoria or in Johannesburg, get a taxing master where they're going to say, I deprive you from a drawing fee because I've taxed off 70% of your bill. So it is still a discretion of a taxing master. You can argue this in front of a taxing master, but it's not like in the Magistrates Court. They do not have a discretion. It's just, I thought, let me just put that 5 cents worth forward to you. I know in Cape Town, where you're coming from, as well as in Bloemfontein, they're very strict with it and they apply it in the High Court and in the Appeal Court exactly the way that you're teaching us. But in Johannesburg and Pretoria, it does not apply.
That's why I also said you need to check. Sometimes they say this, but normally on the drawing fee, the people are normally like sort of, you've done the hard yards, you've drafted the bill of cost, so they will most probably allow the drawing fee. It depends on taxing master to taxing master, where they got their training, how they will approach it. And you can then argue to say, okay, listen, yeah, but there's that discretion, because they do have that discretion, but their discretion should be judicially exercised also. I said that yesterday, it should be judicially exercised, but it's a matter of where you actually have your bill of cost. Then they will most probably allow or disallow. But over the years, I've seen that the taxing masters, they are not so finicky when it comes to the drawing fee. But when it comes to taxation, when that thing kicks in, they will hit you. But obviously, as you say, also in some of the divisions, it's also, you need to know the practices in the divisions and the taxing masters. If you tax a lot, and you start get the feeling. And hence I say, if you're not comfortable, go to a tax, a cost consultant to actually get you going on that front. Mikateko Baloy. Mikateka Baloy. Mikateko Baloy. Mikoteko Baloy. Mikoteko Baloy. Mikoteko. Mikoteko Baloy. I see your hand is up, but I can't hear you. Mikoteko, okay, there's nobody. Mikoteka, if you can, please use the chat box. Then I would now be, okay, Leslie Sampson. Leslie.
Pardon, it's me again. I am probably one of the only students that are not getting these calculations yet. If you would just bear with me for the last time, sir. I'd just like to make sure I understand what's going on here.
Okay.
Is that fine? Thank you, sir. So I see we start with 150,000.
Okay.
Here the 45,000 is more than 20% as well as 25%. So
okay,
that is subtracted,
yes.
But then we don't subtract the attending taxations.
Remember the attending taxations, because they are zero. You see there in the calculation, they are zero because the penalty fees, okay. The drawing fee, I'm leaving the drawing fee on. You are entitled because you've drafted the bill of cost. You've drafted the bill of cost, so your drawing fees on the fees, you get it. So the taxation amount, because your penalty clause kicked in, you're not getting the attendance for taxation. That amount that should have been here is not included, and that's how you work.
Can you hear me?
I'm just busy with Leslie. Mikateko will come to you now. Just give Leslie. I can hear you now.
Oh, okay, my apologies. No problem.
But don't switch off your mic. Just keep it on. Are you covered, Leslie?
No, not yet, sir.
Okay.
All right, then we continue to adding disbursements, the 200,000.
Yeah, you add the disbursements, then you get a subtotal. Now, because the penalty clause kicks in, we're not having amounts for taxation. We don't have amounts for taxation.
Yes.
And then we just move on and we say subtract the disbursement because there's VAT included in the disbursements. Then we get a subtotal of 116,550. And then we say, I didn't give you the VAT rate, so the default VAT rate is 15%. So you say 15% of 116,550, you get the 17. Then you add this amount plus the VAT plus the 200, then you get to this 33403.50.
All right, so I subtracted my disbursements, added VAT, and then added disbursements again. Because you have to work out VAT without disbursement. All right.
Yes.
Thank you so much, sir.
100%. Mikateko, you can come.
All right, thank you so much. So my apologies. When I tried to speak, the system kicked me out. So I couldn't, nobody could hear me and I couldn't unmute myself. But I wanted to ask in terms of the percentages, right? Sir mentioned that it's different with different percentages with different codes. I did not quite catch that correctly. I think it was also the time when I was losing connection. So can sir kindly please repeat that again for me? And then also in when we're writing the exams or when we're studying for the exams, will it say on the question paper or in the exam to say that the amount that has been taxed off, or you have been granted a certain percentage of tax, or you would have to then in turn they would tell you that, okay, this is the amount that has been taxed off, just as your question that you gave us has been taxed off, and then we would have to calculate that, okay, if it's now it's 30% and we're dealing with a high court matter, that means that we cannot add the attending's taxation.
Yes, Mikateko, they will give you the amounts. Normally they would give you, as you can see on the screen, they will give you like these two blocks, like the fees, that blocks they will give to you. Then you have to work out these subtotals now. They expect to know the subtotals. You need to know when the penalty clauses kicks in and those type of things. So you just need to check when is my penalty clause in or not. If it's not in, then I work out my totals. If it's in, I don't need to worry about the penalty clauses. So that is, they will give you that amount, and it's not that different percentages applies to different, how the taxing master applies their discretion. And I think Cora van der Merwe, she explained that very nicely, that different divisions have different ways of doing, or let me say taxing masters in the different divisions Some will say strictly, I will apply the rules, and then if more than 25% is tax off, I will not give you your drawing fee. I will not give you your attendance fee. Some will say, I will give you your drawing fee, but not your attendance fee. So it depends on where you at. Because in the magistrates court, it's sort of half saying that you should not be getting it, but if more than 25% is tax off, but some courts does give you that drawing fee because you've done the work. But technically, if you strictly in terms of the rules, they might not give you that 20, but the 20% and the 25% for High Court and Match Court, it's the same throughout the country. It's just how the taxing master exercise their discretion pertaining to certain things. That is where I think you most probably got kicked out, but that's how they operated.
Oh, okay. No, thank you so much. So I completely understand it now. Thank you so much.
100%. Then Richard, your hand is up. Richard.
Thank you, Prof. I just want to ask you something on the fee structures. I went through the manual and I've worked through it. And then on page 125 of the reader, there's a schedule where they outline various taking instructions and attendance, and then they've got figures, amounts there.
Yes.
For candidate attorneys, for an attorney, must you stick with this figures that's here in this Government Gazette of 3rd of June 2022 that was now amended? Must you stick to those amounts when you do this?
Yes, you need to, if your cost order is in line with the tariffs, if it's party or attorney-client. If you got a cost order on a different scale, which is only in the High Court, in the Magistrates Court, you will be bound by these tariffs. If you are on party, attorney-client, you are bound by the tariffs that sits in here. And then obviously, because remember, if a cost order is granted, it's granted against the opponent. So the opponent will only have to pay up according to the cost order. Whatever is the difference between your actual account as a legal practitioner and what you could recoup on behalf of client from the opponents as per the cost order, you can still get that money from your client. You are not bound by this in terms of your agreement with your client. But in terms of recouping costs from the other side, you have to stick to the tariffs. Are you clear with that one, Richard?
Yes, yeah. And just one last question is, when you stick to this, like they speak about attendance, perusal, and drawing up of documentation, is it for each document and the pages and everything? So if you do it more than once, you can claim more than once for that.
But remember, you must also now go look at, and for instance, let's say, okay, if you say perusal of a document, if you're looking at that tariff specifically in your class notes, now you go to, let's say, okay, we start there. I think it starts somewhere by, let me see, where's that government notice starting? It's starting on page 125. So it starts with definitions, then it gives you what legal assistance to an indigent person means, and then it starts giving you tariffs there. Now it says, here you say, okay, now taking instruction by an attorney, candidate attorney, it says preparation of records, and there is maybe perusal of a document. Now, you cannot charge for perusal of a document if that document forms part of the instructions during consultation. You must just charge for it in the consultation. But if client brings to you a document maybe 3 days or 3 weeks later that you have to actually read and get additional information, you can charge. But then it's also clear as to attendance. You cannot ask for attendance and something, but it's all in the, so it's all necessary attendance. So people will say, I'm charging for a telephone call and attending to the telephone call. You charge for one of them, not the both. Because if you attend to the telephone to answer the call, that cost that you're charging the client is already for that telephone call that you're charging the client, because it says a telephone call is like normally for every 5 minutes or part thereof by an attorney or candidate is 37 or 119. You cannot say attending the telephone call also, then you go for the normal attendance by an attorney. That is maybe like 72 rand for some sort of a thing, or attending on the fax machine to send a fax. if you're sending a fax, that attendance is included in that amount. So that's how the taxing master also looks at these various things. So just be alert and aware to what that is.
Okay, thanks. No, thanks.
Okay, 100%. Sonwabile Kaba and then Patrick Radzuma. Then I will take those two questions. Then I need to quickly speed through the last notes of taxation and the review of a taxation. Then we should be done. And if there's other questions, then I'll remain behind for people to ask questions if they feel and deem it necessary to ask questions.
Okay, sir. Quickly, I just want to take you back a little bit on the magistrate court one, where we added the attending taxation of 11% and 6%. I'm struggling to. I didn't get you when you said the 47,500,000 times 3 divided by 100. We got to that 1,425 to get to 7625. How did you get the 47,500,000?
I say I take the 67,500.
Yes.
I minus 20,000 because remember, on the first 10,000 you charge 11%. So that is already taken out. And the second 10,000, sorry, you charge 6%. So you take another 10 out. So from the 67,500, you take out 20,000, then you are left with 47,500. That's how you get to the 47,500. Then you say multiplied by 3 divided by 100 to get that 1,425. And then you just add them. After you've taken out the disbursements, you calculate your VAT.
Okay. Okay. No, thank you so much.
100%. And then Patrick.
Hey, Prof, can you hear me?
I can hear you, yes.
Yes, 2 questions from me, Prof. I understand you say that in the exams, we're going to be given maybe the 3 figures. That is the fees, the disbursements, and the
text of amounts.
Yes, but are they going to, do they give us this table indicating what we should do so that we can do the calculations, or we do the tables ourselves?
Normally, sometimes they would give the table and sometimes they will not give the table. They will just give you the question paper and then you have to remember these steps in table format, how you work it out. So it depends on the examiner that's drawing up the paper. Sometimes they are lenient, sometimes not. They think that the students need to know every step, so you should be able to work it out in table format. So then they won't necessarily give you the table. So then it's up to you to know exactly what is in and what is out.
Oh, okay. The second question. Okay, no, I get that. The second question would be, am I getting it correctly to say that the penalty in the High Court kicks off at 20% and in the Magistrate Court is 25%?
Yes, it's the penalty in the High Court is 20%, but that 20% is if 20% of the total bill is taxed off, which means fees and disbursements.
Oh, okay. No,
in the Magistrates Court, it's 25% of the fees.
Oh, okay. No, thanks.
So it says that if more than once a litigant presents a bill of costs for taxation and he claims fees under a particular heading, even though he does not allocate a specific money value to the taxing master is entitled to allocate a value to that item before determining whether that item claim should be allowed or disallowed. When calculating the total amount of fees claimed so as to determine whether the sub-rule applies or not, the taxing master is entitled to take into account fees which had been determined were claimed under such an item. Now, so in that they look at more than 1/4 is taxed off. If more than 1/4 is taxed off, you have a problem. And what is that 1/4? That 1/4 of the bill is applicable to the fees. If 1/4 of the fees has been taxed off, you've got a problem, Patrick. So you need to make sure when more than 1/4 of the bill, excluding expenses, is taxed off, the party representing the bill shall not be allowed any cost of taxation. And what is cost of taxation? It's the attendance. So where a party to a bill of course is presents, it makes a written offer of payment, obviously then you will also be penalized if you don't. But what is cost of taxation? It is the attendance fee. So if more than 1%, if more than 1/4 of the bill, not one of the bill, of 1/4 of the fees is taxed off, you know it's tickets, you've got problems. You've got problems. So make sure, and it's excluding expenses. So they look at the fee component only. So shall not be allowed cost of taxation. And what is cost of taxation? Is the attendance, the move that actually forced you to appear. It's not the drawing fee. You're still getting your drawing fee. Your drawing fee, you get it. It's just the taxation costs that you're not getting, which is the attendance. Okay. Right, so let me see now quickly to go to the bills. Okay, there is taxation. So I will now stop sharing that screen and just quickly go to the actual slides again. And I share the slides quickly and just sort of have legal costs. And I hope you guys can see the slides now. The slide should be up. It says you give them 10 days to inspect the documents relevant to your bill of costs. Sandra, I will come to your question. We'll just go through the notes and then I'll dismiss the group that doesn't have questions and I'll stay behind for questions. So write down your question quickly. 10 days to inspect any documents relevant to the bill of cost, and then 10 days to file a notice to oppose the taxation, listing each item which is opposed and stating a reason. So you need to give a short summary of what you're doing, and then you can find it in Uniform Rule 70 sub 3B, or that's where you'll find the notice periods. But you'll see, if you go to the High Court, to the Magistrates Court, it's the very same thing. It's copy and paste exercise. So it's also 10 days to inspect. It's just the rules is different. Rule 3315B and Rule 3316B. That is applicable to the notice periods that you have to give time to inspect, file notice to oppose, listing each item with a short summary why you're opposing it. And thereafter, the other party needs to give 10 days notice of the set down if you guys can't meet each other on the amounts that's in dispute. If you guys can't settle it, then it will go for taxation in front of a taxing master. Obviously, the allocator, we dealt with this, and it's normally right up front, and that is just the sliding scales that you need to take cognizance of at all times. So obviously, once a taxation, once the allocator or the allocator, the grand total, the total allowable fees has been made, it has the same force in effect as a court order. Obviously, you can take a taxing decision. A decision by a taxing master can be taken on review. Although it has the same force in effect as a court order, it's still an administrative function that is performed by an administrator in court. If you're in magistrates court, the district, it's a clerk of the court. If you're in the regional court, it's a assistant registrar. If you're in the high court, it's a registrar or assistant registrar that's doing the taxation. So you take it on review in the magistrates court to a magistrate, in the high court to a judge. The rules that's applicable is Magistrates Court Rule 35 that speaks to how you take it on review. So you will go to the court and say to the court, I'm not happy with what the taxation or the taxing master did. And obviously, when a taxation takes place in the High Court, only a person with right of appearance in the High Court can appear in the taxation. Similar in the Magistrates Court, candidate attorneys can appear on taxation if it's in the district court, because you will have right of appearance in the district court. If you are second year article clerk, you will have right of appearance in the regional court because you've served 1 year of articles, then you can appear for the taxation. But in the High Court, you should not just be an admitted attorney, you should be an attorney with right of appearance in that specific court. So just remember, that is what you do. And once the bill has been taxed, as I said, it has got the same stature as a court order, but it's still an administrative action. And what that bill is the total grand total, and it says it's now the allocator. So the allocator is contained at the foot of the bill. And then obviously you are allowed now to take it on review in terms of Magistrates Court Rule 35 or High Court Rule 48. The decision of taxing masters can be reviewed by either a magistrate or a judge. Both rules sets out the procedure for bringing a review, and it's important to note the review proceedings must be initiated by notice within 15 court days of the taxing master making that decision. From saying, I stamp it today, it's the 7th of July, stamp on there, so you'll have 15 court days. So next week out, that other week out, that other week, until Friday, you have to bring it. So obviously also a bill of cost, you can also by agreement agree on without a taxation taking place. So parties can agree, and it's not uncommon for legal practitioners to agree amongst themselves on what the bill of costs should and should not be. The main benefits for that on agreeing: certainty on amount and saving costs. How do you recover legal costs? Once an allocator has been made or stamped and endorsed by the taxing master, it has, as I said, same effect as a court order, and that you'll find in Magistrates Court Rule 36(2) and Uniform Rule 45(2). And once it's made, it's endorsed, that allocator is endorsed, you can issue a writ of execution, and the sheriff can then, in the ordinary course of business, execute it and take take possession of the possessions of the party who's responsible to pay the bill. So before a bill is taxed at court, notice in terms of the rules must be given to the other side. So that's one of the key things that you need to remember. It's also possible to agree on the amount in the bill of cost between the legal practitioners without formal taxation taking place. The decision of the taxing master can be reviewed within 15 days. And remember, the decision of the taxing master has the same force and effect as a court order. A writ of execution can be issued based on a text bill of cost. Obviously, if you guys agree and you did not get it taxed, then you won't be able to go for the writ of execution. Righto. I hope I shed some light on the topic of legal costs for you guys. If you guys don't have any questions, I will release you guys. It's Friday night. You can go early and go and have a nice hot cup of soup or coffee or tea. But if you have questions, I will remain for the guys who has questions. Obviously, I will give Sandra the floor first because I remember her hand was first. Or if you want to stay behind and just listen to what their questions is, you may do so. Witty, you will speak, and then it will be Cora. So it's first Sandra, you can speak. Sandra? Sandra, I'm listening. Sandra, if your mic is not working, maybe you should log in and out, or you can maybe type in the chat box. Witty, you can go so long.
Advocate, my question is with regards to the exam. So you mentioned that. Is it Sandra?
Oh. No, you can speak with it. I don't see Sandra speaking yet.
Okay, someone's mic is unmuted, but anyway, you mentioned that if the examiner is lenient, they could actually give us the table. So in an event where they don't give us the table, is the question just gonna read, calculate the allocation?
Yeah, they will just say, okay, the fees was this, the disbursements is that, the amounts that was taxed off, calculate the allocation. Then you have to go through the things. Then you have to work.
Okay.
Then you have to work now and you have to know.
All right. Thank you, Advocate.
Sandra, is your mic on now, Sandra? I just want to check, Sandra, is your mic on? Sandra, are you there? Okay, let's go to Cora. I see Sandra is not coming through. Cora, then it's Rachikopa, Tolakela, and then Rachikopa and Tolakela after Cora.
Mr. Hart, it's an interesting just a comment that I would like to make with regards to right of appearance in the High Court. It's interesting, the bills of cost judgment, the SCA judgment, where the taxing masters rely on to say that candidate attorneys and attorneys who do not have right of appearance may not appear before them. That judgment was delivered in 1979. The Right of Appearance Act only came into being in 1995. So I am actually part of an application that will be heard on the 18th of October in the High Court of Johannesburg. Judge Sutherland, the DJP, is the case manager in this matter. So hopefully, I also
It
have...
will change.
I think it will change, and I do believe that the position will change with regards to candidate attorneys as well, because we're relying on the I'm just going to comment and then I'm going to stop. Relying on the rules of the attorneys' professions in 2016 that says that candidate attorneys may also appear at taxation. Now, the interesting part here is the Legal Practice Act came into being in 2014. They repealed the Attorneys Act. And then in 2016, 2 years after the Legal Practice Act came into being, they then published the rules of the attorney's profession in terms of the Attorneys Act. So there is a section in the Legal Practice Act, I think section 119, that says if an act is repealed and the rules are published in terms of that act, rules, conduct rules, and I think it's conduct rules and something else, that will stand. So we have Advocate Reg Willis for the amici, who's acting on behalf of the candidate attorneys, who will then argue the situation for candidate attorneys. So I just want to say, look out for the judgment. It will be the Finyani judgment, and that will be heard on the 18th of October this year.
Thank you, Cora. I also think it's silly to not allow candidate attorneys to appear at taxations, because it's like an administrative process. It's not really where you appear in court. So for me, that excluding candidate attorneys from appearing in it was just some sort of red tape. I can say red tape, which was unnecessary. So I actually know that there is something on the table, because I speak to Judge Sutherland very often, because we have a lot of matters that we have to get through him, because he runs the Joburg office with the roles and stuff like that. So I know also of that application. So, but thank you for actually reminding me of that, Cora, so that that the rest of the crew can also look out for that judgment. It's actually, but I think it's silly not to allow candidates to appear at taxation, because that's sort of like a mini type of trial where you can actually test and groom your skills. So Rachikopa.
Evening, Prof. Hello, can you hear me?
I can hear you, Rachikopa. You can go.
Okay, yeah. My question has to do with the allocator.
The allocator, yes.
Yes, specifically, because I'm a candidate at 10, and what I've noticed is that what I had actually is that in terms of there are fees that are due to the client there, and then there are fees that goes to the attorney.
In the allocator.
Yeah, in the, let's say
the rules.
Yeah,
no, all the monies, all the fees recoveries is done on behalf of client. Yes, we charge at the rates of the attorneys or the candidate attorneys as per the court order, but every fee that is recovered is on behalf of client. It's not your fees as the legal practitioner. It's the money of the client, because the cost is awarded in favor of plaintiff or in favor of the applicant or in favor of the defendant or in favor of the respondent. It's not in favor of the applicant's attorneys, respondent's attorneys, defendant's attorneys, or plaintiff's attorneys. So that you need to just make sure fees is always recovered on behalf of client.
So does that mean that the grand total that we get there, the bottom, the whole amount goes to the client?
The whole amount goes to the client. Remember, your agreement with the client, if you recover that fees and they pay you the grand total, but your client has not yet paid you, you can utilize some of that money for your fees. And then if the bill that you rendered, that you gave to your client is higher than that grand total, your client needs to just pay the difference. But if your bill is less than what you charge what the grand total is there, then you have to give the net proceeds back to the client between the two.
Okay. My question specifically has to do with road accident fund, where there's a contingency fee agreement, and the attorney has already taken his 25%.
But you must remember, road contingency fee, it's 25% of the total allowable from the claim, the claim award. 25%, that's the maximum. Road accident funds is normally not, or the contingency fees is not governed by the tariffs. It's in terms of the contingency fee act. So it's 100% your normal fee and 25% of the total claim award that you have to be within that parameters.
Okay, no, because I asked because I've noticed that normally when bills are getting paid by RAF, the attorneys are keeping those amounts. They're not giving them to the clients.
But then they cannot recoup fees from the client. So if the RAF is making provision for legal fees, it's that provision that they make is towards the legal fees of the client. Then you just need to say, okay, if the RAF already paid you 300,000 as part of the contribution to legal fees, and the total claim amount is maybe say 1 million, which means you are entitled to 25% of the 1 million is 250,000, which means the RAF gave you more than what you're entitled to. So you can't take any more of my claim award. By 1 million, I must get clean from you.
Okay, yeah, no, I understand. Thank you.
100%. 100%. So Rachikopa is out. Sandra, can you hear me? Sandra, can you hear me? Okay, Tolokela. Tolokela.
Good evening, Professor. Can you hear me?
Yes, I can hear you.
My question is regarding the slides. I just want to know whether are we going to get the slides so we can
the slides
use them.
will not come. The slides will not come.
Why? Though, can I ask why?
No way. The Legal Practice Council doesn't want us to give slides to students because they fight with us all the time if we want to give slides to the students.
Oh, okay. I was asking because the previous lectures, they would post the slides on the e-leader, so we would actually have them.
I'll speak to Maskala to hear what she has to say, but I know in past that like they would fight with us about the slides being uploaded because then the students won't read the prescribed materials because they will just stick to the slides. But if they allow us to put the slides on, I'll upload them or send it to Maskala to upload.
Please, because I just feel like your slides are very informative and we could use them together with the training guide for the preparations for the exam.
100%.
But it's okay. Thank you.
100%. Martin and Glovu. Martin and Glovu. Martin and Glovu. Nontando.
Prof,
Okay,
sorry,
Martin.
Prof, sorry, if you can maybe just start that slide one, I can just take a screenshot of it.
But I'll try. I'll speak to Zukisa. I think if she's the course coordinator and she can speak to the people up there, they say I give it, I can give it. I don't have problems to share slides because it's information that's supposed to be in the public domain so that we actually make sure that our PS is up to date and on point with the things. Nontando?
Yes.
Nontando?
Good
Yes.
evening. I wanted to ask about the kicking in of penalties.
Yes.
Yes, I wanted to know more because it seems like I'm so confused. I've been stuck there the entire time.
The penalty clauses kick in the High Court if more than 20% of the total bill at that point in time. So if we work with the example, we say 150 and the 200,000, that was the fees and the disbursements. Then you say the total bill will be the fees, disbursements, and the drawing fee if you are in High Court. If more than 20% is text of the fees and the disbursement amount. In Magistrates Court, if 25% of the fees is text of, then the penalty clause kicks in. That's the only distinction that you have to make. In High Court, it's 20% of the fees and the disbursements is text of. In Match Court, if 25% of the fees is text of, then the penalty clauses kick in.
Oh, okay. Thank you so much.
Martin?
Hi, Prof. Can you hear me?
I can hear you, yes.
Thank you for the lecture. I just wanted to go back at the allocator part, especially the part which refers to the adding of edible taxation of 3% on the remainder of the bill. I've been stuck on that portion and I've been trying to do the maths, but no, it's not going through.
Remember, if you get your bill, and on our first example, before we worked out the taxation, we were on 67,500. That was the amount that is the amount plus the drawing fee plus the disbursement. That was the 67,500. Then we say, because the rules allows us to take 11% on the first 10,000. So you say 11% on the first 10,000, that gives you 1,100. 6% on the second 10,000 gives you 600. So if you say then we've had two 10,000 there, so we must say 67,500 minus 20,000. Then we are left with 47,500. Then that 47,500 is the remainder of the bill at that point in time. Is the remainder of the bill, and you say then 47,500 multiplied by 3% will give you 1,425. And obviously, if the penalty clauses doesn't kick in, then you know you'll always have to get your subtotal for the fees, disbursements, and the drawing fee, and take 20,000 rand off there if the penalty clause doesn't kick in order to get the remainder of the bill on which you can charge the 3%. That's the basic principle that applies there.
Oh, all right. Thank you so much. Noted. And thank you.
100% Martin. Witty?
Advocate?
Yes, Witty?
Can you hear me?
I can hear you.
You mentioned something last night with regards to deposits. That
yes.
Sorry, it just has been on my mind. So you mentioned that if you draft a letter for a client, and then you mentioned that postage and stamps and whatnot that you use to get the letter through, you can actually charge, right? So do you add it onto the bill of costs? And if you are adding it, do you just put it as let me say the sheriff? If the sheriff fees said maybe 200, do you just put it there as 200 and then at the end tally all your amounts, then add input tax?
Obviously, yes. So if you drafted a bill,
Yes.
and if you do interim accounting, you need to also add that on your final bill of cost, but already you've taken money out of trust from that monies. So when you get to the due amounts, it's going to change. So you just need to know when you work with deposits and you take interim payments for your fees and disbursements, you need to bring it into calculation as to what is outstanding at the end. So you'll have maybe the grand total, which is the allocator, less money is paid, and that will be the money that's still outstanding. That's the only thing that you have to do.
All right.
Okay.
Thank you, Advocate.
Umani.
Advocate.
Thank you.
Yes.
Thank you, Prof. I just
100%.
wanted to comment. There's an old adage which says that when you are in Rome, you do what the Romans do. So, as mentioned by one of my colleagues, the other lecturers have been sharing their slides. So, if you could just come to the part with the Romans, please.
Umani, I will just speak to the course coordinator. If they give the green light, then I will upload or give the slides for them to upload. I don't have issue. Public documents, public information.
Thank you.
Richard?
No, thanks, Advocate. I must say once again, very informative. I enjoyed this 2 days. It brought me bad memories of my BCom days. What I want to ask you is, with the 3 sets of practicing legal practitioners, you get the advocate without a fidelity fund, and then you get the advocate with the that takes instructions from attorneys. Now, when you become an advocate with a fidelity fund or fidelity certificate, is this applicable to you, this legal cost and taxation as well? Because you're taking clients from the street, to put it that way.
Yes, when you tender a bill of cost, if you have a fidelity fund, obviously you do trust reporting to the LPC annually. So it means that when you take monies from client, you work with client, you take direct instructions, you need to also then report as per the LPA's code of conduct and the regulations. So these rules will be applicable to you. Obviously, different tariffs will apply because you now an advocate. And obviously, in terms, if a cost order is given in terms of the magistrate's court, you need to look at what is the rule now? 33 something, I think 33.5 or 33.2. And in terms of the uniform rules, it's 69.2. So then you have to comply with this rule. So you also have to work accordingly to actually, when you take something on taxation, give the notice, comply with all these requirements as if you are a legal practitioner and in the attorney field, because now you're acting on with a fidelity fund certificate. So then there's a heavier duty on you in running your practice.
Okay, thanks.
100%. If there's no more questions, guys, Akash? Yes, I can hear you.
I was able to understand and follow through to exactly what you were lecturing today, but I got a bit lost when we're approaching the allocature of a thing. I kind of like get lost with regards to understanding the principles and rules that are applicable to that. So that really got me not to follow with the calculations and how it's done. So I don't know how or whatever advice you can give now for me to catch up with that, because I'm lost completely.
Akash, the best is go and listen to the recording. I know Mascala, they would make the recordings available so you can sort of have listen to the recordings again. Because I'm not sure as to where you are lost. If you could actually point me. The only thing is that I can tell you is like when you work out the allocator, the first thing that I normally look at is my penalty clause applicable. I will first look at if I'm in the magistrate's court, has 25% of my fees been taxed off? If yes, I know I'm not getting cost of taxation, which is the attendance of taxation. I'm still getting my drawing fee. If I'm in the High Court, if 20% of the fees and the disbursements is taxed off, I know my penalty clause kicks in. I'm not getting my attendance fee. That I know cost of taxation I'm not getting. In some High Courts, they might say you're not getting the drawing fee as well as the cost of taxation. But in some courts, they will say, okay, you've done the work, we'll give you the drawing fee in the High Court. But in High Court, 20% of the fees and the disbursements. If more than that is taxed off, you're not getting attendance fees. That's 11%, 6%, and the 3%. If you're in match court, if more than 25% of the fees, the fee component. So if you look at our first part, on our first example, the fees was 50,000 rand, and there was zero text off. So you get that attendance fees of 11% on the first 10,000, 6% on the second 10,000, and 3% on the remainder of the bill. So that is what it is. So that is how you.
What could lead to it being taxed off? What could it result to that?
What can be the result?
To your fees being taxed off.
What can be the result? Because maybe you've applied the wrong tariffs. Maybe you drafted your bill of cost in terms of attorney-client cost order. Meanwhile, back at the ranch, you only got a party and party cost order. Then on the party and party cost order, you are allowed certain things, which is just necessary and properly occurred for the attainment of justice. Whereas by attorney-client, it's a little bit wider. Or maybe you ask for a telephone call plus attendance to a telephone call. Then it means you can only get the telephone call, you can't get the attendance. So they will scratch off items from your bill of cost. There is various reasons why they would tax off amounts from your bill of cost. Then it needs now, you need to know the rules, what is allowed and what's not allowed to be on a bill of cost.
All right, thank you.
100%. Guys, if there's no more questions, let me see there in the chat, guys. Let me just see. Thank you, thank you, thank you. Pleasure. Pleasure. Thank you. Thank you.
Your email address, perhaps, if we need some clarity so we can email you.
Hey, I'll put it there if you need to sort of have email me, but I don't know how much of emails I read because I'm most of the time not in the office, but I'll try and read, or I'll read at 12 o'clock at night your emails, but I'll try.
Advocate, I think you should share the slides in order to avoid an influx of emails.
100%, guys. Have a good evening. Enjoy your weekend. I hope I've sort of have shed some light on your cost issues. Till we meet on another sphere, maybe it matrimonial or criminal court practice or whatever they normally I do.
Thank you, Prof.
Thank you so much, Advocate.
Thank you.
Good night, everyone.
Bye, guys.
Thank you. Have a good weekend.
Good night.
Bye.
Thank you. Bye.
Bye, guys.
Sorry, that's okay.